Today we're going to talk about Chapter 7 Bankruptcy. Chapter 7 Bankruptcy is the chapter of the Bankruptcy Code that most people think about when they hear the word bankruptcy. It means a filing of a bankruptcy to liquidate one's assets or to shut down a business. Chapter 7 is open to virtually anyone that wants to voluntarily file a bankruptcy. That means individuals, corporations, nonprofit corporations, partnerships, pretty much any person that wants to avail itself of Chapter 7. In Chapter 7, there's a trustee that's appointed, and the trustee is usually a lawyer or an accountant who sits on a panel of trustees for the particular district in which they live, who is charged with analyzing the debtor's assets and liabilities and hopefully finding assets that can be sold to satisfy the claims of creditors. Once a Chapter 7 bankruptcy is filed, the debtor is required to file a schedule of its assets and liabilities and his or her or its statement of financial affairs. Once that happens, there will be a 341 meeting set. 341 is a section of the Bankruptcy Code that talks about a meeting where the trustee will analyze the debtor's assets, liabilities, and try and find out what happened. Why did the person or why did the corporation file bankruptcy in the first place? The 341 meeting is also an opportunity for creditors of the debtor to appear and ask questions. Those can be similar questions to the ones the trustee is asking. What happened to the business? What happened to the person? But also might be about where did assets go? How were certain liabilities incurred? And generally trying to find out what kind of assets the debtor does or does not have and what caused the bankruptcy filing. The other goal of the trustee is to liquidate all of the debtor's non-exempt assets to generate cash to hopefully satisfy claims of creditors. When we say non-exempt, the debtor in a bankruptcy case, individual debtors, are entitled to exempt certain assets and certain dollar amounts of those assets for themselves, meaning pull them out of the bankruptcy estate, and these are assets that cannot be liquidated by the trustee. But the trustee will, if the debtor has non-exempt assets that can generate cash, sell those assets so that there can be a distribution made to creditors. At the end of the process, individual debtors obtain a discharge, so they get to discharge all of their debts. Corporations do not get a discharge, but it's a very effective way of winding up a business and shutting down the business and getting all of the right processes done to do that. In an individual bankruptcy, though, creditors do have the ability to file a complaint to determine a debt or all of the debtor's debts non-dischargeable. These usually arise from things like fraud or other bad acts that the debtor may or may not have committed to create the debt in the first place. If there's no determination that a debt or a number of debts are non-dischargeable, then the individual debtor will receive a discharge at the end of the process.
Chapter 7 Bankruptcy is the filing of a bankruptcy in order to discharge personal debts, liquidate one's assets, or to shut down a business. Once the bankruptcy is filed, the debtor must file a schedule of its assets and liabilities and a statement of financial affairs. After this occurs, a 341 meeting is scheduled, which is where an appointed trustee analyzes the situation in the hopes of determining what caused the bankruptcy filing. The trustee analyzes the debtor's assets and liabilities, seeking assets that can be sold to satisfy creditors' claims. At the end of the process, an individual debtor is able to discharge his or her debts. Debts are determined to be non-dischargeable if illegal acts, such as fraud, were committed to create the debt. Corporations do not obtain a discharge, but it is an effective way of shutting down a business. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.